You should repeat those.
Add it on.
3 minutes.
You barely in the room at all. And I brought coffee. Very much so.
Good afternoon, everyone, and welcome to the CLE on Federal Assisted Housing 101, Section 8, Public Housing and More, Basic Housing Volunteers Need to Know, or the basics that housing volunteers want to know. Quickly, just want to introduce yourself. My name is Mariah Kruger. I'm the Housing Program Manager and Resource Attorney at Volunteer Lawyers Network. I also want to give another shout out to another VLN housing staff member here, Steve Swanson, if you want to raise your hand. He joined our staff not so long ago, and he's here to assist with our housing program. We're happy to have him. A couple other quick announcements before I introduce Dorinda, our speaker here today, and let you get started. I want to let people know about a new resource that we have at the Housing Court. It is for Hennepin County, and it's Help to Stay in Your Home or Apartment. It's a listing of financial resources that are available to clients when they're going through the eviction process. So the brochure, we tried to keep it really simple, not too many resources, but enough to send people in the right direction. It's going to start by referring people to Hennepin County Emergency Assistance, but then also listing other resources that are available to people if they have been denied by emergency assistance. So if you have people coming through the Housing Court project and they need help with financial assistance, please use this brochure to help send them in the right direction. One other thing I just wanted to let people know is I'm developing a web page for VLN volunteers that's going to house the resources that we use to train our volunteers. Right now the web page isn't going to be searchable, but if you ever get an email from me, the website is at the bottom of my email, and that's just vlnmn.org/housing-volunteers with an S. And on that, I'm going to be uploading this presentation when it's done. I also have like our volunteer handbook for the Housing Court projects. I've got a training for our Ramsey County Clinic on there, and also an Eviction 101 presentation there too. So it's just a good spot for people to go for resources if you find yourself just wanting to brush up on something or to let someone new get trained in who's not able to make our presentations. So with that, it's my pleasure to introduce our presenter today. It's Dorinda Wider, who's a staff attorney with Mid-Minnesota Legal Aid. She comes to us with a wealth of experience. She's been with Mid-Minnesota Legal Aid for 34 years now, and her area of specialty is in housing in VAWA. Specifically, she works with federal assisted housing and also with housing discrimination and fair housing work. So please, let's warmly welcome Dorinda Wider.
So, it's exciting to see all of you here, although when I see all of you here, I think some of you could be up here doing the basics. So, I might be calling on you to answer certain questions. When Mariah asked me to do this, the assumption is that this is really basic. You know, I've done this for a really long time, so if I wander off into the weeds and I'm speaking jargon to you, or you just think, oh my God, I'm not going to build housing, I just want to save somebody from losing it, call me back. When we sort of took the training materials from training that I did for our new attorneys, we got a batch of new attorneys about a year ago, 5 of them, and so we've reduced some things to slides so it looks really slick. I was drawing pictures, and that's why the whiteboard's here. So we'll see if we can do it with slides. I'm going to assume that you may have taken a housing case that may have involved subsidized housing, but that most of you probably haven't, but you could. And what I hope we'll do is get you sort of comfortable with figuring out, okay, the person sitting across from me has identified that they're in subsidized housing, or I just think nobody could live anywhere for $8 a month, so it must be subsidized housing. And what does that mean I ought to be looking at in addition to all of the stuff you've already soaked up for 504B, because all of that applies. So all of that applies, and the magical world of HUD and the IRS get to intrude with statutes and regulations as well. So the first thing, if we're lucky here, the first thing we're going to do is, I'd like you to watch this because my colleague at the Urban Institute draws much better than I do. We can skip the ad. And we were hoping for a sound, but perhaps we don't have it. We're not going to get the sound. So I'm going to spare you this and cut to the chase.
Can you just narrate?
Yeah. If I could narrate as quickly as she could draw, that would be truly miraculous. The gist of it is, and you can watch it when you get home, is what happens is housing is not an entitlement. It's not like you're poor, you meet the eligibility, and you suddenly then can get housing until you're no longer poor. That's not true. It's if you're eligible, then you might get a place on the waiting list, and once you get on the waiting list, you might get housing, but only 1 in 4 of you will get housing. The rest of you will be on the waiting list. So it's not an entitlement. That's why it's really valuable. That's why we want to keep it. And here in our area, it's particularly valuable. I'm sort of preaching to the choir here because you know that poor people don't have money and housing is expensive. But we have an area median income of $94,300. That's for the 9-county, the standard statistical metropolitan area. For the people we're serving, they are what HUD has categorized as extremely low income or very low income, which means they're at 50% or 30% of the area median income. And that's still pretty high because the ELI, the extremely low income here, is 28.3. If you're getting MFIP or TANF for welfare for 1 adult and 1 child, you're getting $437 a month. That's $5,244 a year. That's significantly less than 28.3, which makes you extremely low income. And it is just not even in the room for $94,300. If you're getting general assistance, you're getting $203 a month, $2,436 a year, and you are way beyond or below ELI. What that means for our clients is when we're talking about affordable housing and creating affordable housing, and we're talking about let's create affordable housing for 50% of the area median income, we're still not talking to the people who are talking about housing for the people who are living on MFIP or living on general assistance. It's not going to house the guy begging out on the street on Nicollet Mall. Their incomes are not going to get them eligible for that. The standard rule, if you took financial planning or budgeting in high school, I talked to a high school class recently, and they still teach that. The idea was 30% of your income is what you should be paying for housing. 30% of that MFIP income is $132 a month for rent. You're not going to get that in the private market. If you're on GA, general assistance, you're going to be on general assistance because you're single and you're disabled or waiting for your disability from the feds. It's going to be $61 a month for 30%. What HUD has figured out for housing programs, the voucher program, the fair market rent for a 1-bedroom, decent, safe, and sanitary unit of modest, not luxury, is the definition. They have to include that, not luxury, is $915 for our area. So you're not going to make it in the private market. If you're working, the housing wage here, if you're working, you've got to work at minimum wage 61 hours a week to afford a fair market rent. And if you're on Social Security disability, it's completely out of the question. It would take 112% of your monthly income to afford a fair market rent, one bedroom. So that's why we care. So we have these people, four of them are eligible, one of them gets housing, hoorah. What happens with the other three? They're on the waiting list. Waiting lists are long. This tells you what the average waiting list is right now in this area. Right now, today, this morning, I checked for what waiting lists are open because they're not open all the time, because once the waiting list gets so long that you can't conceive of getting to the end of it if you're running the program, then they're closed. So there's 18 listed and 15 of them are closed. These waiting times are average, sometimes it's longer. And if you talk to someone who says they're on the waiting list and they think they've been on it for 3 or 5 years, and you think, oh my God, 3 or 5 years, so you're on the voucher waiting list, you should be coming to the top soon. There's this shuffle because you might have been on there 5 years, and we pick off the first 50 on the list to offer them our 25 vouchers that we have. And you'll find out that they no longer satisfy the preferences or their family composition has changed. And so you might have been at the top of the list for 5 years, but now you're back down somewhere in the middle. So there's this constant shuffling. So even though someone tells you they're on the list, that's good. You can't win the lottery if you don't enter. But that doesn't mean that if they've been waiting 5 years, it's coming around the corner. It's not.
What's an example of someone that would move up the list, you think, and still be down?
So if you've been waiting on the list and you applied when you had 3 kids and you've waited 5 years and now you've got 1 kid because 2 have aged out of the household, and suddenly you're on the waiting list and we have a 3-bedroom unit voucher to offer you, but you're clearly not eligible. Or you were working in Bloomington at the time you applied and there's a preference for people who work in the jurisdiction, and 5 years later you're not working in Bloomington anymore, so you no longer have a preference. The person behind you in line who does have that preference goes ahead. And it all takes place kind of behind a curtain, so you don't really know. You kind of know you've been on there a long time, but you don't really know your place. And if you call and ask, where am I on the waiting list, they're not going to tell you not because they're mean, but because they frankly really don't know. You know, you're on the list. That's what we can tell you. You're on the list. Yes?
My question is, how would they know that your job has changed from Bloomington to somewhere else?
Oh, because once you reach near the top and I see that I have subsidies to give away or I have vacant units, I will contact the people on the waiting list near the top, and then you have to re-verify your eligibility. We have to make sure you're still poor enough, that you still have the right household composition, that you still meet the preferences. And if you don't anymore, then you'll drop down.
And Dorinda, would you remember to repeat the question?
Oh, thank you. Yes?
Is the time you spend on the list a factor?
The question is the time you spend on the list a factor? Kind of, in that, you know, if you have all the preferences and you've been on there 5 years, you're going to be closer to the top than someone who applies last year, because you're going to be on that list by date and time of application. But there's that constant shifting, the wait list shuffle. And then periodically, an agency will look out at their piles of files and say, oh my God, we're never going to get to the bottom of this. Let's update our files. So they'll send everybody at the address that they had 5 years ago a letter saying, are you still interested in subsidized housing? Please reply in the next 15 days. If you don't get the letter or you don't reply, then we assume that you're not interested, and we purge the list, and suddenly the pile of files is smaller. But for somebody who didn't have their mail follow them through their 5 or 6 housing situations, they may not even know they're purged until they call up to see if they're still on the list. So
doesn't seem like that would be fair, though. I mean, these people move around a lot.
Oh, yeah, it's not fair at all.
How many are going to have their mail follow, you know?
It's not fair at all, but it's a huge administrative burden to have to keep track of everybody. And it's demoralizing to know that you have 5,000 people and only 2,500 of them are actual applicants because everybody else has moved or died. So, no, it's not fair. But as you will find out, it's hardly the most unfair thing we're going to talk about. So it's you know, this housing that somebody will tell you that they have or they think they have or you think, looks like you might have it, is really like the golden ticket. It's like, you know, it's like Willy Wonka and you've got the golden ticket. You got to fight to apply for it. You got to fight to find it. You've got to get through the application process. You have to survive the wait list shuffle. You've got to, once you get it, hoorah, and if it's a voucher, you have to find a place to use it. Or if you get a subsidized unit, great. Now you're going to have to remember that there are all kinds of requirements that come along with it, not just abide by the lease, don't trash the joint, be nice to your neighbors, but there's other things like recertify your income, tell us about who's living with you, where are they, how long have they been with you, I'd like to inspect your house on Tuesday at 3 o'clock. Oh, you're working. Well, that's too bad. I'm inspecting on Tuesday at 3 o'clock. So there's all kinds of things that happen. Neighbors are especially interested in whether their tax dollars are being spent on somebody who's worthy. Everybody has expectations, and you live with those expectations. Now, the payoff is you live with subsidized rent, which is a golden ticket, but there's expectations. And sometimes you brush up against those expectations, and you will see somebody sitting across from you who's facing not a termination or an eviction yet, but facing well, we call them a come to Jesus talk, but that's not really what it is. For some agencies, they call it a proposed lease termination. Other agencies will call it a concern letter. We're concerned your neighbor says somebody's living with you and we don't know that. Come in and talk to us. And so you need to take those seriously. Our clients have to take them seriously. We have to take them seriously and respond to it because the next stop is termination. And then, of course, you have to fight the termination. Could be a notice to vacate, could be a termination of assistance, and for some bases for termination, it could be a termination for life. You not just lose it with the Minneapolis PHA, but you lose your eligibility for subsidized housing anywhere in the country for the rest of your life. You go in the HUD big book of bad people. They don't call it that, but they do have a list, so it really exists. So you've got somebody talking with you in clinic. You know, you can ask if they're in subsidized housing. You should ask if they're in subsidized housing. They might know. You can ask, and you always do know how much the rent is. Considering the market, looking at their income, does it look like it's maybe subsidized? No, as I said, nobody lives for $8 a month rent. On the other hand, 30% of your income is what the rent is about. But if people are in low-income housing tax credit rental, which we'll talk about, then the rent might be more than 30% of their income, but less than the market. So does it look hinky? That's kind of the rule. You can ask, if you move, is your subsidy going to go with you? Clients will usually know that. If you're tossed in the hearing today, is your subsidy going to go with you? The answer to that will tell you kind of what housing program they might be in. Do you have to report your income? If your income increases or decreases, do you have to tell somebody? You know, when I was a renter for 20 years, I didn't have to tell anybody, but if I were in one of these programs, I do. Do you have to ask where they do the reporting? That will help you figure out what program they're in. Do you have to report downtown in St. Paul? Then it's Metro HRA. It's probably not St. Paul. St. Paul PHA people only live in St. Paul. St. Paul vouchers don't get rented in Minneapolis. Do you report at 1001 Washington? That's where the Minneapolis PHA office is. Do you report to the on-site manager's office? Then maybe this is project-based housing. So ask, do you report and where? Ask where they applied, because that may help you narrow down what agency it is. If it's really one of those hoorah kind of moments, they have their lease. Or if it's an eviction, the landlord had the foresight to follow the law and attach the lease. So you can tell from the lease. Leases will tell who owns the place. Leases will tell what the terms are. One of the handouts that you have is a chart that thank our colleague Larry McDonough and the National Housing Law Project for amassing that, and it will tell you lease terms that are peculiar to certain programs. And so if you see the lease, that will tell you. Certain kinds of project-based housing that we'll talk about uses a form lease. It's always the same lease. You don't get to choose. So you'll be able to see it. It'll say Minnesota Housing Finance Agency in bright letters across the top. And sometimes, if you're lucky and it's a termination, the complaint will actually say that it's a subsidized housing unit. It should. You'd think that would be a key term in talking about or describing the tenancy, but sometimes they don't. So if you have a clue and you think it might be, these places will help you sort of figure out more. There's something called the Housing Links stream. Housing Links has this database where if you go to this link and you type in Halcyon Village, if it's subsidized, it'll pop up and it will tell you how many units there are, who the owner is, and it will tell you what kind of subsidies in there. And then you can go back to your other chart or to the regs or wherever and see. So this says it's project-based Section 8. Then you know what land you're in for what kind of rights and obligations there are. Low-income housing tax credit is much harder to find. These two sources are about the best we've got. The second one listed there, the preservation database, will ask you to register in order to use it, but that doesn't mean that anything bad will happen to you and you won't be flooded with email. But it's sponsored by the National Low-Income Housing Coalition, and they want to know who's using them. It will help you identify low-income housing tax credit properties because they are outside the HUD system and they are hard to find. And since that's where most of the money for development goes right now, they're there, they're out there, we just have to find them. And then if you think it's project-based or your client says, if I move, the subsidy stays with my apartment, which is why I really need to stay there, you can go to the HUD Minnesota office website and search for a subsidized apartment, and it will bring up the list of the HUD subsidized projects. And if you're trying to help somebody find housing, it's also handy to have them get that list. It's all sorted out nicely by county. And for those kinds of projects, you have to apply on site. So you can give it to a client and they can apply. So you all know 504B, use it all the time. That's great. Here's all the other stuff you need. There's the statute. This is the HUD statute is 42 USC. And for the housing tax credit properties, those aren't HUD. Those are through the IRS, through Treasury. Regulations for HUD housing is all in 24 CFR. Those are all on the chart. It's helpful to find HUD guidance where HUD is saying to providers or to housing authorities, this is what the regs, we think as the administrative agency, this is what we think the regs require you to do. Then there's, for public housing, there are plans, annual plans that they file. Those are all on their websites, and that's for public housing and vouchers. Public housing will either call it admission and continued occupancy policy, or they'll call it a statement of policies, either an ACOP or an SOP. Admin plans, administrative plans are what covers their voucher programs. Those two will be on the website. That lists all their procedures, all their policies, what they think their policies are. Remember, these policies aren't approved by HUD, they're just looked at by HUD. yes, I see your policy. I'm not reviewing it, I'm not sanctioning it, I'm not approving it. I've seen your policy. It exists. So sometimes the policies have illegal things in them. That's why you have to check the law as well as the policy. But the policy is what the agency or the housing provider thinks they're doing. So it's good to look. If you're in low-income housing tax credit land, it pays to look at the land use agreements. Those are filed. You and the attorney for the landlord are probably the only people who've ever looked at them. The person who filled out the eviction notice certainly didn't look at them. Then there's something called the HAP contract. Your client tells you they have a voucher. So there should be a contract. HAP stands for Housing Assistance Payment. Contract is going to be relevant. That's between the agency and the landlord. And there is a tenancy lease addendum that is mandatory, and it has important rights for the tenant in it. We'll talk about those in a minute. Then you can look at the lease. And building rules, project rules, house rules, sometimes those are also incorporated in the lease, so you need to look at those. So let's talk about housing. There's way too many kinds, and you'll see on the chart there's way too many kinds there. I want you to just be able to sort of figure out if you've got public housing, because this is where you're going to start, public housing, Section 8 vouchers, project-based housing, or have you fallen into the abyss of Treasury and you're in low-income housing tax credit land? Public housing is lots of different agencies. Biggest one in town, Minneapolis Public Housing Authority, has about 8,000 units, somewhere around there. Keeps changing. The smaller housing authorities, Richfield or Hopkins might have a small project, maybe 50 units. So there's a few others floating around out there. You can tell it's public housing if it's property owned by the PHA, or it could be property managed by the PHA. Heritage Park, which sits just north of downtown, is owned by the PHA, managed by McCormick Barron. You don't really want to know why, but it is public housing. And if you look at the lease, it'll say it's public housing. If you look at the property information records for the county, it'll say MPHA is the owner. You can tell from the language of the lease, it will sometimes say it's PHA. They will talk about a grievance hearing, and you'll care about that and want to talk to your client about that. That'll be in the lease. Sometimes you have to just Google-ate it and look at what the sign says in front of the building. There is no level to which we won't stoop to try to figure it out. And if worse comes to worse, you can always ask. Sometimes the property management person will know what the subsidy is, sometimes not. You can ask the local HUD office. It's hard to get a person on the phone there. They used to be staffed fully and people would answer the phone. Now you get an answering machine usually, and you get to leave a message, and someone in probably 48 hours will return your call. I don't think there's more than a handful of people there behind the screen. Or you could call us and ask, or trip down the hall if you're at the clinic and ask. We know some of them just because we deal with them all the time. To get into public housing, you're going to see people who are not only seeing you in clinic who are getting booted out or who are having problems in it, but you're going to see people who say they're trying to get in or they've been denied. So to get eligible, they've got to be low income. That doesn't seem to be too hard for most of our clients. At least one person has to be a U.S. citizen or an eligible non-citizen. I am not an immigration lawyer. I know that there are 7 categories of eligible non-citizens. If you wanted to know what they were, I could scruffle in my pile of papers and find that list. I wouldn't be able to tell you what they mean. It's set by regulation. I know that certain kinds of legally permanent residents, LPRs, are on the list. I know that certain asylees and refugees are on that list. I know people who have a U visa or a VAWA category are on that list. But when I have a question about eligible non-citizen, I have to get out the regs, look at the list, and then go find an immigration lawyer. We have those, so if you don't have one on staff, feel free to call ours. But if there's one citizen, that's great. They're eligible, even if the citizen is a child. So we could have non-citizen adults and one citizen child, and they would be eligible to apply. The rent will figure out for them at 2 different rates, because if they're not an eligible non-citizen, they cannot receive HUD benefits. So there'll be a separate rent for the non-citizens and a separate rent level for the citizens or eligible non-citizens. You might find out that people have preferences. They applied, they were asked questions. Are you homeless? Are you a vet? Are you working here? Do you go to school here? Those are all going to be relevant. Some places everyone has the ability to have a preference for victims of domestic and sexual violence. Most people don't have a preference. Some agencies do. Then after you apply, then you're screened. And screening takes place, when you apply, screening takes place, preliminary screening takes place right away, so that we can figure out, you don't qualify, you got too much money. You don't qualify, you don't have citizenship or eligible non-citizens. You don't qualify because you live someplace else entirely. But then, as you get closer to the top, you're going to be screened again for actual admission preferences. And for public housing, you're going to be screened for rental history. You're going to be screened for credit history. You're going to be screened for criminal history. You're going to be screened for landlord references. And when people come to you and say they've been denied, they will have a denial letter, and it will say why they've been denied, and they have 10 days to ask for an appeal. If you look at why they were denied and it doesn't, and your client says they've dinged me for felony history and I'm not that Robert Smith, then that might merit further investigation. If your client lied on their application, they're just toast. Whether they had a good reason for lying or not is conjectural, but they have to be truthful on that application. You won't know if they lied. You can ask them if they told the truth on the application, and certainly they will tell you they told the truth as they understand it to be or as they understood the questions, but you may need to actually look at the application file to decide, are you going to assist them at that appeal hearing? For Minneapolis PHA, which is the biggest public housing program, the appeal hearing is quite elaborate compared to other programs. It's a full-fledged, hearing. There's 3 people sitting as a tribunal, 2 employees who haven't reviewed the file, 1 employee, and 2 tenants who don't live in that particular housing. They live, if you're applying for family housing, they might live in seniors housing. You have to convince 2 of them that you either meet the categories or the qualifications, or that somehow something applies that should get you over the hump, either reasonable accommodations or maybe VAWA, the Violence Against Women Act. You can't be denied for anything that's a direct result of sexual assault, dating violence, domestic violence, or stalking. So that's what happens at that hearing. There's no record. The rules of evidence don't apply. It can be kind of a circus. It's always entertaining. If you lose, then you have the right to either seek a petition for cert with the State Court of Appeals, or you can just flat out sue them if they violated the law. Those hearings, if there is a legal argument to be made about why you got denied, are almost impossible to win if you don't have a lawyer. I don't know if any of you went to those hearings, if the PHA's attorney would show up. I know that if any of us, legal services attorneys, say that we're coming to the hearing, then the PHA's attorney shows up. Usually she doesn't, unless it's us. We're special. public housing rent, your clients are going to talk to you about, even if they're not being evicted, they're going to talk to you about rent because maybe they're disputing the rent calculation. You have to report your income changes. You have to report loss of income, increase of income. This thing called EIV will come up. It's a way of doing income matching between everything except the IRS is matched with what you reported. So if you're in and you have 3 crummy little part-time jobs and some of them are sporadic, you only report 2. When it comes time for your recertification, there will be a discrepancy because we know that you have 3. The SWCA hours show that you had 3. This is going to be a problem. You've underpaid your rent, maybe, depending on whether they're accurate. The EIV, a big dispute that will happen is the agency will say you can't see the EIV. They will say that to the tenant. They will say that to you. By law, both you and your client can see it, and you must want to see it. In public housing and in Section 8 housing and in project-based housing, there is a minimum rent. Pay 30% of your income for rent, adjusted income. There's some deductions for certain kinds of things related to medical deductions, some child care deductions. But the minimum rent is $50. That means if your rent income is very low, remember GA income, your rent would be $61. But you should be paying $50 at least. In Minneapolis, because Minneapolis is engaged in a demonstration project called Moving to Work, there are 39 PHAs in the country doing this, and one of their experiments is, would it meet the statutory requirements to make people self-sufficient or save public money if people paid more? The minimum rent is $75, just because. I don't think it makes people more self-sufficient. I'm not sure it saves a great deal, but it's $75. Everywhere else it's $50. So if you have a problem with your rent and you've underreported or it's been miscalculated and problems happen and people do the math wrong and sometimes you reported everything and they didn't get around to calculating it on time and you went a few months paying the wrong amount and now you're on the hook for $1,000 and your income is $400, so $1,000 is really hard to come up with. They can enter a repayment agreement. It's discretionary with the PHA. Public housing doesn't have to. Project-based does. Public housing might. If you owe more than $5,000 and it's because of an error that you made that you didn't report, then that's going to be reported to the Office of Inspector General for fraud. $5,000 is the cutoff. So it will be turned in, and you still might be invited to sign a repayment agreement. That won't stop the investigation. It won't stop the federal marshals from showing up on your doorstep. And you won't get back into public housing ever. Evictions in public housing, as with the other subsidized housing, it's usually serious or repeated lease violations or other good cause. You can park a truck in other good cause. There's 30 days notice. There's got to be written notice. It's got to tell you what the violations were, unless it's a crime that is drug-related or violent, in which case they will bypass any sort of administrative hearing and go right to court. With non-payment cases where I just didn't pay the rent, for public housing, you have 14 days to cure that. You're supposed to get a notice. Dear Bob, you didn't pay the rent. You owe the rent. We want to see your $50 or your $75 by the state. And you have 14 days to cure. That's by regulation, by statute. So you get that. You will see in non-payment cases that you're seeing in the clinic with public housing that they will sometimes be asking for months in which they haven't yet given the 14-day notice. So your client might not owe 3 months' worth of rent. They might only owe 2 because the agency has jumped the gun and given the notice or given the eviction complaint without proper notice. We've explained this to them repeatedly, and they thank us for sharing. And if we are on the case, we can get the court to say, okay, you didn't give a 14-day notice for November here, but you're asking for September and October. Mrs. Smith, do you have September and October? You do. Oh, that's good. And do you have a filing fee? Well, that's a problem. But you can get that month that they haven't given proper notice swept. On the days that they have their calendar, if you're at Housing Court Clinic that day, you'll notice that they have a calendar all their own, and there are 50, 75 hearings. Lots of times people show up with the rent by then. They've got it from wherever. Or they show up to make a repayment agreement. Lots of times there is just a big guy with a zipper bag collecting the money in the hallway, along with the agent of the PHA, one of their employees, who's sort of running the show. There are probably many of those people committing to pay money that they don't necessarily owe because the complaint is wrong, but they're not getting picked off there. But if somebody talks to you about that, look for the 14-day notice. If you're not bypassed and going directly to court, and we're going to evict you because you violated the lease, you have crappy housekeeping, you broke something and didn't pay for its repairs, you have somebody living with you that isn't on the lease, you're too noisy, any of the things that would be lease violations. If it's not a crime and nobody's in danger, you have the option in public housing for administrative process before you get to court. You will get a notice that says, these are the things you've done wrong. Beware the notices because they will be multiple pages. They will look like everything you've ever done, ever in living there. And it's not only the bad things you've done. It will list the bad things you've done, like, well, there was a police raid and we found drugs and guns. And it will list things like, we came to inspect your apartment on Tuesday and you weren't there. Not all of those are serious and repeated violations of the lease. Oftentimes you might want to, if you're going to represent this person, you might want to do a motion in limine to get the notice sort of narrowed to what is actually, if proven, a violation of the lease. But you get the notice, and on the notice it will say you have an opportunity for an informal conference. That's you, a representative if you bring one, the management person from your building or your project, and the theory in doing that and putting that into the laws, that's a place where if there's a problem, we can fix it. That really depends on how much enthusiasm we have for fixing things and how much interest you have in keeping this tenant. But it's a place to fix it. You as the representative or the advocate might want to go to that meeting because if nothing else, it's a place for free discovery. You can find out what really they're upset about, and maybe you can come up with a solution. It's a place, if you're doing a reasonable accommodation request, to make it and perhaps short-circuit going to court. After you have the meeting, they'll send you a note saying, we met, we talked, you agreed to do X, Y, and Z. We're not going to go to court or proceed with the eviction because you're going to do X, Y, and Z. Or they'll say, we met, we talked, we were not impressed, and do you want to have a formal hearing or do you want to just go straight to court? The formal hearing is a good idea. For one thing, you get to live there longer. The formal hearing is a due process hearing, often in front of a hearing officer that's a mediator. Sometimes it's a hearing officer who's not a employee who's reviewed this file. Sometimes it's an actual tribunal of 3. Remember, you only need 2 votes out of the 3 to stay. The rules of evidence don't apply. There is no record unless you make one. They used to prohibit making a record, but they realized that was illegal, so now we can make a record. And you go and put on your case, and you'll find out if you get to stay. At the very least, if you can't go to that hearing, helping the client prepare for it is useful. Because they're going to need to figure out what are the real problems, how can I make a pointed and orderly presentation and not get distracted by other things, and I have to convince two people. What is my most convincing argument? If you lose at the administrative hearing, then the next stop is housing court. You've got to go to court. The grievance process can be used by tenants if they have a grievance against the housing authority, but it rarely is. So that's the wonderful world of public housing. Public housing authorities and others run voucher programs. Voucher programs, your client will say they've got a voucher. Every client wants a voucher. Every client needs a voucher. Every client says they really, really don't want to be in project-based housing or public housing. They really want a voucher. The reason is because it looks more like regular housing. You can go out and rent housing that better meets your needs, maybe. It's not usually as high density. And in the past, as Mariah said, I've done this 34 years, so having a voucher actually used to get you housing. Now it just gets you a housing search. It's very difficult to find a place to use your voucher. Nevertheless, you either got one or you want one. You can ask your client if they have a voucher, ask them who gave it to them. They'll know the agency that issued it. That's important because you'll find out that there's special vouchers that have some special rules. What happens is we got money that comes from Congress to HUD. HUD gives the money to the PHAs. The PHAs then give a voucher to the tenant. The tenant has 60 to 120 days to find a place to rent. The place they find has to be decent, safe, and sanitary. It has to be renting within the fair market rent limit, and it has to be willing to sign a lease with them. So they find that very difficult commodity to find. They sign a lease with the landlord, and that lease is then shipped to the agency who reviews it, not for illegal lease provisions, not for fairness, not for much of anything except the term should be a year, and for the location, it has to be in the agency's jurisdiction, and for the rent level. Then they the agency sends out an inspector to inspect to see if it will pass the housing quality standards. Those are set by federal regulation. Many landlords complain that they are stricter than passing an inspection by city code. If you read the housing quality inspection code, you'll see it doesn't seem very strict at all, but I think people object to being inspected. So you have to pass the inspection. While you're having this process of having your lease reviewed for the rent level and the inspection is ongoing, your time is told. So you have 120 days, maybe at the most. You got to use your voucher in that 120 days. You got to get it leased up, completed in 120 days. But we won't be counting that time against your 120 days. If the rental falls through, it doesn't pass inspection, the landlord at the last minute pulls out, then the clock goes back on and you keep searching. If it passes inspection, and we hope it does, then the landlord and the PHA will sign the contract. So this is the unholy triumvirate of Section 8 vouchers. So the PHA and the landlord sign the HAP contract. That says the PHA will send the landlord X number of dollars every month. It's usually an electronic transfer. It comes at the end of the month. Comes like clockwork. It's figured out that this is the rent. Deduct from that 30% of the tenant's income, and that the remainder, roughly speaking, is what the PHA sends. The tenant and the landlord sign a lease. That lease, whether it has it in it or not, incorporates the HAP tenant lease addendum. And if there's some conflict between the lease addendum, which is dictated by HUD and by regulation, and the lease addendum controls. Landlord's supposed to attach it to the lease. I've probably seen that happen 7 times in my life. But it doesn't have to be attached to be effective. It exists, it's a form, and it doesn't get altered. And if you are dealing with an eviction or an issue for a voucher tenant, pull it down from the HUD website and wave it about because it has important protections and obligations in there. So that's sort of the relationship. If there's a problem, the PHA is not going to intervene and solve the problem. They are going to send the money. They're going to send the money as long as the place is up to code, to the HQS standard, and any problems during the tenancy are going to be worked out between the tenant and the landlord. You get a voucher, the same kind of screening happens. It's the same kind of citizen-on-citizen thing. It's the same kind of criminal history review. It's all of that. But you don't look at the PHA in giving you a voucher, won't look at your credit history, won't look at your rental history. They leave that screening to the landlord. So they will know whether you have manufactured meth on site because they will deny you a voucher. They know whether you are a lifetime registrant sex offender because they will deny you the voucher. And they will know if you have been evicted in the last 3 years for a drug-related criminal activity from assisted housing because they will deny you the voucher. But other than that, they're not going to know anything, and they're going to leave that decision to the landlord. The rent, as I said, the rent's going to be like 30%. There's a minimum rent here, $50. You still have the EIV being used to figure out what's been reported as income. And the tenant, if their rent drops, can ask for their rent to be recalculated. And you're still working within that market rent limit that's in the lease, but how much each person pays, the housing authority or the tenant might vary because my income went down, so now I will pay less and the housing authority will pay more. That recalculation is supposed to take place within a month. Sometimes it doesn't. And so you might wind up in court because you were paying and then you lost your job and you asked to be recalculated. It didn't happen on time. You didn't pay enough. The agency didn't pay more, even though they would have technically been responsible to pay more. And now we're in court on a non-payment issue. If you can figure out the rent and get the agency committed to doing a calculation, then you can maybe get the landlord to back off on the eviction. The other thing that your client will maybe talk to you about and may show up in clinic to talk to you about has nothing to do with termination, but has to do with the magical world of porting. The nature of a voucher is that if you got one, you can go anywhere in the country after the first year. If I'm Minneapolis, give you a Minneapolis voucher, you fill out a year in my jurisdiction, and you decide you want to move to Hilo, and who wouldn't? You can. You contact Hilo. Do they have a Section 8 program? Great. And then you do the paper chase of porting, and it's a lot of paperwork on both ends to make that move. You can imagine the number of things that can go wrong with two burdened administrations and having to get that to happen. So porting will come up and your client will say, I'm porting, but something has happened, or I want to port and they're not going to let me. Why can't I port? I find the porting regulations very difficult to pick through. I think my clients find it equally difficult. So if that's the problem, it's a porting issue. You got to act quickly because remember the voucher's only good for 120 days or less. If it was issued for 60, it has a 60-day expiration date on it. You got to use it somewhere, here or in Hilo. Get your stuff organized. Time is running. If it expires before you ask for an extension, it's gone. No do-overs, no mercy. It's gone. So if you need an extension past the 60 days, ask before the last day and make sure you get it in writing. So porting is difficult. If somebody says they're having problems with porting, feel free to associate with somebody on our staff who maybe also is confused about porting like me, but at least we can pick through it together. But realize that it's time sensitive and it's extremely complicated. So terminations with vouchers. If somebody's talking to you in clinic and they're facing an eviction today for non-payment or for violating the lease, for some other good cause, if they get evicted today, they will be noticed to have their voucher terminated. So you're not only going to lose your tenancy, but we are going to kick you out of the program. It's going to happen in 2 separate steps. The court's not going to terminate your voucher. They're just going to terminate your tenancy because you got evicted. So you got to win them, obviously. If there's any merit, we got to win them. The other thing is we have to be really sensitive to settlement, because what we say and what we document in the reason for settlement could be good in it settles the matter and the landlord and the tenant are both happy, but they are still on the line at risk of losing that voucher. So what the settlement says is really important. You can't lose. Yes?
It wouldn't maybe this is a dumb question, but if it's a Section 8 issue, wouldn't it normally be non-monetary? Because if the Section 8's in place, they're getting paid. Wouldn't it be like breach of lease issues more than?
Oh, you'd be surprised. So the question is, aren't these just non-monetary Section 8 evictions? No. Agencies pay late. They shouldn't, but they pay late. Or the landlord is asking for more money than the agency and the tenant are obliged to pay, which not only violates the lease, but also is a potential False Claims Act violation with significant federal penalties, which should get the landlord heart pumping a little bit. Or there's a problem with inspections. If it's inspected, so we're in year 2 of, or getting close to year 2 of the tenancy. We got in, it passed inspection, everything was great. Year 2 is coming up, we have to do a new inspection, and it doesn't pass. And the landlord gets a notice from the Section 8 agency that these 3 things have to be fixed. Landlord doesn't, or does, but doesn't do all 3, does just 2. Another notice, and usually a 3rd notice. And then, because we can't pay, as an agency, can't pay the HAP payment because it's not up to code, we don't make our payment. So now all the landlord got was $178, and he didn't get the other $1,000 because the agency can't pay if the inspection hasn't passed, and that'll wind up in court. And the landlord, by the contract and by the lease addendum, is prohibited from asking for anything other than the tenant's portion of the rent, but surprisingly large number of landlords ask for the full freight. It says specifically you can't ask for the HAP payment from the tenant, but they didn't read that part. It is a 10-page document, this contract that they signed with the agency. They didn't read that part. So it's not always conduct or breach. It's oftentimes money. The money part should work as you hoped, like clockwork, but it doesn't. So you get, you will also get clients who say that they're being evicted because it's at the end of the lease, but it's not. So you need to separate that out from terminations. I want to tell you about 3 kinds of vouchers that you need to be aware of. Family unification vouchers, VASH vouchers, those are for vets, and Bridges vouchers, which are for people with serious and persistent mental illness, and it's funded not by the feds, but by Minnesota Housing Finance Agency. Those vouchers act a little differently, so if a client tells you they have them, you have to look at a different section of the regulations. Project-based housing has all the same stuff. Same stuff as far as admissions, same stuff as far as cause to evict, same stuff about rent calculation. You just have a different landlord. You have a nonprofit or a for-profit agency that got the money directly from HUD, or from the State Housing Finance Agency that got it from HUD. And that's the landlord is evicting. The one thing you need to look at here is the handbook, 4350.3. It's on the HUD website. It is a gold mine of tenant obligations and landlord obligations. Landlord must do every single thing just right, and they're very picky, and they lay it out in great detail. So look at it at HUD clips and follow it. So eligibility, admissions, rent, all of it's the same. The last weird creature, and then we'll wrap up. The last weird creature is the low-income housing tax credit program. It's not a housing program. It's not a housing subsidy. Treasury would tell you that they don't know anything about housing subsidies. The rent isn't tied to income. It's a way of creating more affordable housing. It's a way of giving a tax credit benefit to the syndicate that funds the creation of the housing. And it is the best thing that you need to know as tenant advocates is if your client's in low-income housing tax credit property, good cause is the key. They can't end the lease without good cause, and they can't evict you without good cause, and good cause is pretty much how we get the court to define it, because Treasury couldn't be bothered. So good cause. Remember those words and look for it. The other thing to remember is if you're a low-income housing tax credit owner, you cannot choose to not participate in the Section 8 voucher program. If I come and I qualify in every other way and I have a voucher, you must take my voucher. As you know, in the private market, that's not true. It's the law, you must, and they will. But you may have to remind them that they must. So, all of those things about low-income housing tax credits, you can look at. Those are the weirdest ones, but that's where the money is, and that's where the newer buildings are. Remember that you can't be evicted without cause. Remember that you don't have to pay an application fee to apply. Remember that just because you're not a citizen doesn't necessarily mean you're ineligible. Remember that there's due process of various sorts and degrees. Remember that it's absolutely essential to know what program it is to figure out what all of those degrees are. And remember to call us if you're totally confused. But you shouldn't not take those cases. Yeah, some of them are really complicated. Others are just pretty straightforward. It's like, you can't evict me for not paying the half payment. It's against the law. So take that case, win it. If a person's facing a termination from public housing for something that doesn't seem like it's actually a lease violation, take the case. It's not rocket science. It's just sometimes complicated. Okay?
Have a quick question before you finish?
Sure.
How do you tell if you're dealing with the LAHTC?
The LIHTC or Section 42. Usually you can tell because if you can look on the database. If it doesn't seem to say Minnesota Housing Finance Agency on the lease, it's maybe not project-based. It doesn't say HUD on the lease, then it's not a HUD thing. And if it's less than the market rate rent, but it's not 30% of income. $500 for a one-bedroom unit. Good deal for a fairly new building one-bedroom unit. Client doesn't have a lot of income, more than 30% of her income, but it doesn't seem like that's market rate. So you can look at the database to see if it's listed. You can sometimes just look at the stream, the Housing Link stream, and it will say that it's a low-income housing tax credit property. They should identify themselves on the lease, but it varies. And there's nothing that requires it, so it kind of depends on how detailed they wanted to make the lease, because the lease can get to be 14 or 15 pages and nobody's read it. Any other questions before we go? Yes.
Are Section 8 and Section 42 from the, what are they?
Well, Section 42 is sort of shorthand for LIHTC or low-income housing tax credit, refers to Section 42 of the IRS code, which is where you'll find the very few and limited regulations for the program. Section 8 refers to Section 8 of the Housing Act of 1937 as amended. subsequently, but it refers to that. And so it actually encompasses both the voucher program and the project-based program. Any other questions? Good, go forth, represent them. They're not that hard.
Big thank you once again to Dorinda Wider, our presenter here today, and also a big thank you to Great Plant Moody for hosting us, and Dean Eiler and staff member Lori Kleinschmidt for all their help in organizing today. Also, if you haven't signed in and would like to get CLE credit, please do sign in at the back to make sure that you can get the CLE credit. It has been applied for. So thank you again for coming. I look forward to seeing you all again soon.
Well, yes.
Like a recipe. I'll just look it up. I'll look it up, or I'll just